Good morning, everyone. How are you? This time, we will have lesson number 3, and we will be talking about quasi-judicial power. What is quasi-judicial power or quasi-judicial power? It is the power of administrative authorities to make determinations of facts in the performance of their official duties and to apply the law as they construe it to the facts so found. It partakes the nature of judicial power but is exercised by a person other than a judge. In other words, class, quasi-judicial power refers to the authority granted to administrative bodies or agencies to decide on certain matters that require the interpretation of law and the determination of facts. While these bodies do not have the same authority as courts, they are empowered to conduct hearings, gather evidence, and make factual determinations and apply the relevant laws to the cases or issues brought before them. In the context of the Philippine law, quasi-judicial power is frequently exercised by various administrative bodies and agencies such as the Civil Service Commission, the Securities and Exchange Commission, the Energy Regulatory Commission, and many others. So these agencies are tasked with implementing and enforcing specific laws and regulations within their respective jurisdictions. Remember, my example before was the National Labor Relations Commission or the NLRC. I told you before that they are empowered to adjudicate labor and employment disputes. So the NLRC has the authority to conduct hearings, receive evidence from both parties, and render a decision based on its interpretation of labor laws and the facts presented during the proceedings. The decisions, class, made by the NLRC can have significant legal consequences for both employers and employees, similar to those rendered by our traditional courts. And that power to adjudicate labor and employment disputes, such as cases involving unfair labor practices, illegal dismissals, and collective bargaining disputes. That power is called quasi-judicial power granted by our law to the National Labor Relations Commission, which is an administrative agency. Now, how do we construe the jurisdiction of quasi-judicial agency? An administrative body to which quasi-judicial power has been delegated is a tribunal of limited jurisdiction, and as such, it could wield only such powers as are specifically granted to it by its enabling statute. Its jurisdiction is interpreted strictissimi juris. What does this mean? Strictissimi juris, class, means that there should be strict construction of law when it comes to quasi-judicial agency. This principle dictates that administrative bodies or agencies exercising quasi-judicial powers can only exercise the authority explicitly granted to them by their enabling statute or legislation, meaning it has a limited jurisdiction and can only act within the scope of their statutory authority. So for example, if a statute establishing a labor relation board grants the board the jurisdiction over a dispute related to collective bargaining agreements but does not mention jurisdiction over wage dispute, then the board would not have the authority to adjudicate wage disputes. Example lang yan, ha? So its jurisdiction would be limited strictly to matters explicitly outlined in the enabling statute, meaning you cannot settle dispute beyond what is given to you by the law. So suppose, class, an employee of a government agency files a complaint with the Civil Service Commission alleging wrongful termination from their position. The employee claims that their termination was politically motivated and violated their rights under civil service regulations. So in this scenario, the jurisdiction of the CSC or the Civil Service Commission would be construed strictly according to its enabling law. What is the enabling law of CSC or the Civil Service? Is the Civil Service Law, which is Republic Act number 2260. The law outlines the powers and responsibilities of the Civil Service Commission, including its authority to adjudicate employment-related disputes within the civil service. So what happened pala in the example? The employees were wrongfully terminated and according to them, it was politically motivated. Now, for example, if the enabling statute explicitly grants the Civil Service Commission jurisdiction over cases involving alleged wrongful termination and violation of civil service regulations, then the Commission would have the authority over their particular complaint because it is specifically granted to them by the law. However, class, what if hindi pala kasali sa power ng civil service ang mag-adjudicate or mag-settle ng disputes involving wrongful termination? What would happen? If the enabling statute limits the jurisdiction of Civil Service Commission to specific types of employment disputes or excludes certain categories of employees from its purview, then hindi po pwedeng i-accept ni CSC ang pag-solve ng dispute. For example, if the statute specifies that the Civil Service Commission only has jurisdiction over disputes involving regular civil service employees and not contractual or casual employees, then the Commission would not have authority to adjudicate the complaint of a contractual employee. In simple words, class, quasi-judicial power, when granted to an administrative agency, must have a specific jurisdiction or coverage, and it is interpreted strictissimi juris. Now, class, when an administrative agency has a quasi-judicial power to settle disputes involving their specific sphere of expertise, we also have to look at the administrative due process. Now, what is the nature of administrative proceedings? It is summary in nature. And when we say administrative due process, class, this refers to the fundamental principle that individuals are entitled to fair treatment and procedural safeguards when they interact with administrative agencies. So this principle ensures that individuals have the opportunity to be heard, present evidence, and challenge decisions that affect their rights or interest in administrative proceedings. Again, the nature of administrative proceedings is summary in nature. Administrative proceedings are typically characterized by their efficiency and informality compared to those with court proceedings. So, they are designed to be streamlined and less formal, allowing for quicker resolution of disputes and administrative matters. So, this means that administrative agencies may have the flexibility to adapt to simplified procedures and rules tailored to their specific functions and objectiveness. When we say summary in nature, class, it offers greater flexibility compared to court proceedings. And this allows agencies to adapt their procedures to the particular circumstances of each case. So this flexibility enables agencies to focus on the relevant issues and evidence without being bound by strict formalities that are common in our traditional judicial proceedings. Meaning, class, it is less stringent, and the main goal is to make the process more accessible and user-friendly for individuals who may not have legal representation. But despite being summary in nature, administrative proceedings must still strike a balance between the interests of the parties involved and the public interest or regulatory objectives being pursued by the agency. Again, is administrative proceedings bound by technical rules of procedure and evidence? The answer is no. The technical rules of procedures and of evidence prevailing in courts of law and equity are not controlling in administrative proceedings to free administrative boards or agencies from the compulsion of technical rules so that the mere admission of matter, which would be deemed incompetent in judicial proceedings, would not invalidate an administrative order. For example, class, where a government agency is conducting an administrative hearing to determine whether a construction company violated environmental regulations during a building project, so during the hearing, the agency allows the admission of certain documents and testimonies that would not be typically admitted in a regular courtroom due to technical rules of evidence. So for instance, the agency may consider informal statements from local residents. Pwede sila mag-interview sa mga tao na doon lang dito sa office sa company. Pwede ra po sila mag-observe sa environmental damage caused by the construction activity even if those statements would not meet the standards of admissibility under traditional rules of evidence. So additionally, the agency may adopt more flexible procedures for presenting evidence, such as allowing parties to submit written affidavits or expert reports instead of requiring live testimony in all cases. So, the rules of procedure of quasi-judicial bodies shall remain effective unless it is approved by the Supreme Court. So again, quasi-judicial bodies typically establish their own rules of procedure to govern the conduct of hearings. So the submission of evidence, the issuance of decision, and other procedural aspects of their functions covered na siya sa own rules and regulation ni administrative agency. So these rules are designed to ensure fairness, efficiency, and consistency in the resolution of cases. However, class, Always remember that while quasi-judicial bodies have the authority to promulgate their own rules of procedure, kini siyang mga rules are still subject to review and approval by the Supreme Court of the Philippines. So being the highest court of the country, the Supreme Court has the power to review and regulate procedural rules to ensure uniformity and adherence to the fundamental principles of justice. Meaning, si Supreme Court class na siya'y oversight authority to ensure that the rules of procedure established by quasi-judicial bodies conform to the legal principles and standards. So for example, si NLRC na siya'y sariling rules of procedure governing the filing of complaints, the conduct of hearing, the submission of evidence, and issuance of decisions. However, this is still subject to review and approval by the Supreme Court to ensure consistency with legal principles. What then are the cardinal primary requirements of due process in administrative proceedings? There are 8. First, the right to a hearing, which includes the right to present one's case and submit evidence in support. Second, the tribunal must consider the evidence presented. Third, the decision must be supported by evidence. Fourth, such decision must be substantial. Fifth, the decision must be based on evidence presented at the hearing or at least contained in the record and disclosed to the parties affected. Sixth, the tribunal or body of any of its judges must act on its own independent and consideration of the law and facts of the controversy arriving at a decision. 7. The board or body should render decision that parties know the various issues involved and reason for such decision. And the officer or tribunal must be vested with competent jurisdiction and must be impartial and honest. So let us try to discuss these stuff one by one. First, the right to a hearing, which includes the right to present one's case and submit evidence in support. This means that individuals involved in administrative proceedings have the right to be heard, present their argument, and submit relevant evidence to support their case. So for example, in a disciplinary hearing for a government employee accused of misconduct, the employee has the right to present witnesses and documentary evidence in their defense. Second, the tribunal must consider the evidence presented. Meaning class, the quasi-judicial body are required to carefully consider all the evidence presented by the parties before making a decision. For example, class, in a licensing hearing for a professional, pwedeng doctor, pwede lawyer, so the licensing board must review and evaluate the evidence presented by both applicant and any opposing parties before deciding whether to grant or deny the license. If you have presented your evidence, of course, the decision must be supported also by evidence. For instance, in a zoning dispute between property owners and local planning board, the board's decision to approve or deny zoning variance must be supported by evidence demonstrating compliance or non-compliance with the zoning regulations. It is also important to note that the evidence must be substantial. It must be substantial class so that you can justify the outcome. Like in a tax assessment case, for example, the tax authority must provide substantial evidence to support its determination of tax liability against a taxpayer. Number 5, the decision must be based on the evidence presented at the hearing or at least contained in the record and disclosed to the parties affected. So parties involved must also be informed of the evidence considered by the tribunal in reaching its decision. So for example, in a bid to protest for a government procurement agency, the agency must disclose to both winning and the losing bidders the evidence and arguments considered in its decision. The tribunal or body of any of its judges must act on its own independent consideration of the law and facts of the controversy arriving at a decision. Meaning, administrative tribunals must independently evaluate the law and the facts of the case before rendering a decision. So for instance, in an environmental regulatory proceeding, the environmental agency must independently assess the relevant environmental laws and the specific facts of the case before issuing a permit for a construction project. The board or body should render a decision that parties know the various issues involved and the reason for such decision. Here, administrative decisions should clearly outline the issues considered by the tribunal and provide a reasoned explanation for the decision reached. So in a social security disability hearing, for example, the administrative law judge should clearly identify the medical and vocational factors considered in determining whether the claimant is eligible for benefits. Lastly, the officer or tribunal must be vested with competent jurisdiction and must be impartial and honest. So for instance, in a land dispute before a government land tribunal, the tribunal members must have the legal authority to adjudicate land disputes and must act impartially without bias towards any party involved. Always remember that the essence of procedural due process in administrative proceedings is the opportunity to be heard, meaning the opportunity to explain one side or opportunity to seek reconsideration of an adverse decision.